In the know.
Good evening, everyone.
In the know.
Tony Reeves, fire. Following the news in any way, shape, or form. No shortage of things to talk about. What does it mean? What will it bring? Is this a reality we simply have to accept? Tony Reeves, fire. Tony Reeves. Let's go ahead and get started.
Welcome back to another edition of Q&A Social Security Disability Today. I am your host, Attorney Anthony Reeves, and we are continuing on with our, I believe it's a 14-part segment of Step-by-Step Guide to Understanding Your Disability Hearing Notice. Part 6, Remarks. In the Remarks section, that's typically where they address experts that may be there. Okay? Usually there's going to be one or two, a vocational expert and a medical expert. Let's start with the vocational expert first, and we'll talk about it a little bit, understanding what their role is. In the second part of the show, we'll talk about the role of the medical expert. The vocational expert, first of all, I need you to understand one thing. Neither of these experts are there to decide whether you're disabled or not. They're there solely as expert witnesses. A vocational expert is there to provide expert testimony about the types of work that you've done in the past that in accordance with the Dictionary of Occupational Titles. Because a lot of times people, when you do work, a lot of the works are usually what we call composite jobs. They're usually a hodgepodge of jobs. Even though it may be described as one thing, the person usually does other types of tasks. So they want an expert there who's going to, one, identify the kind of work that you've done. Why is that important? That's important because Social Security has to decide whether or not your limitations gives you the ability to go back to do those kinds of work. Not only the work you used to do as you normally performed it, but also has this performed in the national economy. And you say, well, I don't understand, what does that mean? That means that a job that you have, even though it may be categorized as doing one thing, you may have done it so differently that you perform it differently than the way it's normally performed in the national economy. So they want to make sure when the judge is looking at your case, can you do the job as the way you did it? Or could you do it as it's normally done? So that's the one part, first thing. So they're going to be listening to your testimony and reviewing your file so they can identify the work that you've done in the past. Then the judge then asks what we call a series of hypothetical questions. These hypothetical questions are designed to take your age, education, and work background in consideration, and then the limitations the court believes that you may have under certain sets of hypothetical scenarios. Now, here's something you need to understand. You don't know which hypothetical scenario Social Security the judge is going to be relying on. So sometimes the judge will ask a bunch of them with different portions. They'll say, so somebody who is 47 years of age with a high school education or more, or work experience similar to the claimant, but they had the ability to only do light work. And in addition to light, these additional limitations, they'd have to have, frequent bathroom breaks, above and beyond the normal schedule, 15 in the morning, 15 in the afternoon, and 30 minutes for lunch. They may be off task for like 10 to 15 minutes during the course of the day, 10% of the day. How would that impact the person's ability to do the work that was listed by the claimant, which would be you? And then the expert gives a testimony, and you're thinking, oh man, I'm in there. But then the judge goes for the rump shaker. Are there any other jobs out here? So the expert then testifies about what other work that may be available based on that hypothetical scenario. The judge may give 4 or 5 different hypothetical scenarios, and the one that the judge believes the medical record supports is the one that they will focus on. So if they focus on the scenario that says there are jobs that can be done, and they believe that's the one you mirror, you lose. If they focus on the one that says there are no jobs, then you win. You won't know which way they're going, but I'm just saying that's what the vocational expert is there for. It's to basically render testimony about the impact of those limitations in the age, education, and work background on the ability to do the work that you used to do, and discuss if there's any other work that might be available in the national economy. Don't go anywhere. When we come back, we're going to talk about understanding the role of the medical expert.
Under the Social Security regulations, representatives are permitted to practice before the administrative agency anywhere in the country, which means that when you're looking for a representative, you can find someone who doesn't necessarily have to be in your state if you're just going before the administrative agency. So it's possible to have an attorney or representative who's from Utah, even though you may be in Georgia. And our office is actually no different. So if you're wondering which states we cover, check this out. Now the tricky part is once you have to sue the Social Security Administration. Under that situation, you want to have an attorney that's representing you in your jurisdiction. So if you have a representative who's in another state and you've gone all the way to the appeals council and you've been denied and you want to sue the Social Security Administration, you make sure you ask that representative whether or not they can sue someone in that particular state.
In some rare instances, a judge may have a medical expert there. And first of all, let me just let you know, the medical expert could be anyone. I mean, for purposes, it could be a general practitioner, it could be a specialist. I've had experts who were psychiatrists, psychologists, orthopedic surgeons, rheumatologists. It just depends on what the judge believes is necessary. What that expert is there to do is to provide expert testimony upon reviewing all of your medical evidence. And upon reviewing all of your medical evidence, giving an opinion about one, do they believe that the medical evidence supports that you meet any of the listed medical conditions that's in the file? That's step 3 of the 5-step process. If they don't believe you meet the listing or even equal a listing, it's meet or equal. We could talk about that in another video if you want me to, just let me know. Then they ask the question, what limitations based on first of all, they'll say, let me back it up. First, the judge will probably ask them, based on a review of the medical evidence, what diagnosis do you see? Upon reviewing the medical evidence, does the claimant have medical evidence that supports meeting any listings? If they say no, the judge may say, upon reviewing the medical evidence, does the medical evidence support that the claimant equals any listing? Based on your review of the medical evidence, and please provide the reasoning for your interpretation of these limitations. Please let me know, please let the court know what specific limitations that what specific limitations does the claimant's medical records support, and what evidence are you relying upon in making that determination? So then what happens is the medical expert will then go for a detailed discussion about, this is what I think. The person may be able to sit, stand, push, pull. The person may have difficulty concentrating, yada, 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 dealing with the public. And the judge may also ask, based on a review of the medical evidence, at what point do you believe these conditions were at this particular level? And the person could say, well, especially if you've got a situation where there's medical improvement or the medical evidence shows it's kind of a waxing and waning, sometimes you're good, sometimes you're bad. The doctor is there to really provide an overview of your medical evidence, what your diagnoses are, whether you meet or equal listings, what your limitations are. And that is what they're there for. Now, here's the kicker. Either expert, vocational or medical, you're going to be given the opportunity to cross-examine them. You could challenge them. This is really important. This is not I don't agree with you, doc. You say that type of situation? Or, sir, I don't know what you're talking about because I can't do those jobs. No. You have to make sure that you are going for pinpoint, precise types of arguments in terms of certain things. Meaning if you're like what? Like, for instance, if you know that you have to go to the bathroom at least 5 to 10 times a day, and that you're in the bathroom from 2 to 3 minutes at a time, ask the vocational expert. Assume an individual that would have to go to the bathroom 5 to 10 times a day and would have to be in the bathroom at least 2 to 3 minutes each time, and the 5 to 10 times a day would go are unpredictable times. Would that individual be able to do the work that you just mentioned? Boom. Now, mind you, don't just throw stuff out there and think, okay, hopefully it'll stick. You want to give information that's supported by your medical records. Same thing with the medical expert. Like, if you, for instance, let's say that you have problems where you're using the bathroom, like I just said with the vocational expert. You ask the medical expert, does the evidence supports the finding that an individual may find themselves having to go to the bathroom 5 to 10 times a day? 5 to 10 times a day for at least 2 to 3 minutes at a time. And then the expert will testify, this person has this kind of condition, and it's reasonable to assume that they would have to go to the bathroom frequent times. Frequency is a relative term, but 5 to 10 is not unreasonable. Boom. Now you've got it narrowed down. But here's the thing that I've got to stress. If you don't know how to specifically narrow them down in terms of getting the testimony that you need, because the testimony is designed to do two things. One, to hopefully paint your case in a more favorable light, but two, present some good evidence on appeal in the event your case gets denied. If you don't know how to frame your arguments in such a way, or frame the examination of these witnesses in such a way to get the information you need to get some help. Because let me be real, sometimes those experts are trying to be accommodating. So if you don't know how to get them to answer the questions that you're looking for a particular response, you may hurt your case as opposed to help it. So if you're not sure, please reach out to a representative, get some help. All right, everybody. Hope you enjoyed. We're going to be back to talk about Part 7, your right to request a subpoena. So that'll be tomorrow. So make sure you tune in right here to Q&A, Social Security Disability Today.
I want to thank all of you for engaging in the videos. Make sure you take the opportunity to send me any comments or send me any particular questions that you want me to have addressed here. As you know, this show is for you, and so the only way I can make sure that I can provide you some good information is if you provide me some good questions. Keep them coming, and right here on Q&A, Social Security Disability Today.